Good morning, and thank you for joining this morning's NJCAR webinar, Managing Workplace Risk Post-COVID. I'm Brian Hughes, NJCAR's Director of Communications. This NJCAR's Office Manager Controller Workshop is typically a very popular full-day live event. Has obviously been upended by the COVID-19 pandemic, so the Coalition has chosen to break the training up into several free webinar modules. Today is the first module, and you'll hear from Dina Mastellone, Brigette, Eagan, Yongji Park, Keith Krauss, Douglas Solomon, and John Vreeland, all from Genova Burns. Judy Vann of JV Solutions and NJCAR's Anthony Anastasio are also on today's call. Honestly, of all those names, I did not think Dina's was going to be the one I was going to murder. Today's webinar will focus on the latest updated labor and employment issues related to getting back to work in whatever the new normal is, as well as the COVID-19 pandemic's impact on your business. Presenters will discuss the Paycheck Protection Program Flexibility Act, small business grants, how to ensure a safe workplace, return to work guidance, wage and hour issues, as well as all the latest employment-related information from the state of New Jersey, OSHA, CDC, DOL, and every other acronym you can think of. Before we begin, I just have a few quick housekeeping details. On the right-hand side of your screen is a control panel. I'd like to point out the questions tab in particular. During the call, all participants will be muted. Also, if the other presenters, if you're not presenting at that particular time, if you want to mute so we don't have any background noise, just remember to unmute yourself when you have to talk. If you have a question during the presentation, we ask that you write it down. We'll give you a heads up when the webinar is about to wind down, and you can submit your question in the tab if it hasn't already been answered. You're going to get a lot of information in the next 45 minutes or hour, so your question may very well get answered. So now I'd like to turn things over to Judy Vann to formally introduce our first presenter.
Good morning, everybody, and thank you, Brian. We certainly miss being at our venue and having you all in the room and being able to share this experience. But luckily in this COVID environment, we've been able to do these managing workshops via webinar, and I guess it's become the new normal. So thankfully, as you can see, Genova Burns has been a tremendous asset to NJCAR. Dina has been our #1 speaker at all of our office manager workshops the last few years, and we definitely appreciate everything that Genova Burns has done. Anthony Anastasio, many of you have spoken to him. He's our head of legal and regulatory affairs at NJCAR. He is our lawyer, is in every day, and I'm sure many of you call him on a daily basis, especially with what's been going on recently. So whereas Anthony normally would open up, we're going to leave Anthony for the end. Anthony, is that okay? And he's going to wrap up all the stuff that you're going to hear today. So as you can see, Genova Burns has pretty much sent us, I think, a big portion of their staff. So the only thing I'm going to do is I'm going to break it down as we go through the presentation as to who's presenting what, so you can know who the experts are in each of these fields. So we're going to start, I guess, with Dina. You want to do your little disclaimer here about it's not legal advice. You should have an attorney-client relationship. So please don't look at this as legal advice. And this is the disclaimer that we're going to start with. We're going to start with Doug Solomon, who is a partner. I'm sorry, Dina, go ahead.
No, I was only going to say we're also going to share the PowerPoint with NJCAR members. So for the participants, NJCAR will post that, and it'll be provided for all attendees as reference material after the webinar. So feel free, obviously, to take a look at it, and always go to our website. Our last slide has everyone's contact information, and feel free to reach out if you have any other questions. Thanks, Judy.
Perfect. Thank you, Dina. All right, so we're going to be starting with Doug Solomon. He's a partner at the firm's labor law practice group, and he concentrates his practice in the area of traditional labor law on behalf of management clients in both private and public sectors. So he's going to be talking to us today about the updated OSHA and CDC guidance for back to work. So Doug, I'm going to turn it over to you.
All right, great, thank you. Good morning, everyone. As a partner in the Genova Burns Labor Group and chair of our firm's OSHA practice, I've spent the past 3 months dealing almost exclusively with giving guidance to employers on COVID-19 issues. It's been quite a ride for car dealerships over the past few months. A little history to recap. As you guys know, on March 21st, New Jersey shut down all dealerships and permitted only maintenance work to be performed. Then on May 20th, the state agreed to consider car dealerships as an essential retail business, but allowed customers to enter by appointment only. And as of this Monday, that restriction was finally lifted, so long as dealerships adopt policies applicable to essential retail businesses that were set forth in paragraph 1 of Executive Order 122. Given these ups and downs, everyone in this industry, similar to me, is dealing with the impact of COVID-19 on a daily basis. And that is, unfortunately, that is not going to change for some time. We all just have to accept that. I'm going to focus my discussion today on the guidance that has come from OSHA and the CDC, the Centers for Disease Control, related to the coronavirus. It's more important than ever that every business is aware of this guidance so that they can not only keep their employees safe, but also keep themselves safe from the potential litigation and the hefty fines that could result from not complying with this guidance. OSHA, for those who need a little background, is the Occupational Safety and Health Administration. It's the federal agency that's tasked with ensuring that employers provide safe and healthy working conditions to employees. OSHA can conduct inspections and fine employers that fail to do so. Many employers we find that are not in the construction or the manufacturing industries have really paid little attention to OSHA over the years. OSHA usually comes up and is thought of in the context of physical injuries. But with COVID-19, OSHA is now being raised in every type of workplace, as keeping employees safe from the transmission of the virus has become front and center. So complying with OSHA's guidance, as well as the guidance from the CDC, is going to be crucial, not only for OSHA claims, but for all types of employment litigation related to COVID-19. In late March, OSHA put out its guidance on preparing workplaces for COVID-19. And I'm going to talk about that guidance today, and specifically the steps that OSHA is recommending that employers take to reduce the risks of COVID-19 in the workplace. And the most important step described by OSHA is to develop a COVID-19 preparedness and response plan. That was really the main gist of their guidance. And so what is that? It's a comprehensive written plan that sets forth everything that your company is going to do in response to COVID-19 and the risks that it poses to employees. This document should really be prepared and distributed to employees as soon as possible if it has not been done yet. The plan should be consistent with the latest OSHA and CDC guidelines. For car dealerships in New Jersey, this plan should also be consistent with all the requirements specified in Executive Order 122. For these reasons, it's highly recommended that employers prepare the plan with the assistance of legal counsel. The failure to develop and implement a plan creates the potential for significant liability with OSHA if a business gets inspected due to a complaint by an employee alleging an unsafe workplace. And we've seen a lot of those with our clients already. I'm going to discuss some of the things that OSHA recommends be included in the plan, but this is by no means a comprehensive list. So the plan should, first of all, determine the sources of potential exposure that employees would have to COVID-19. So how frequently and under what circumstances do employees come in contact with customers, the general public, and coworkers? The plan should also implement basic infection prevention measures. These are a lot of the things that I'm sure you've heard about and that are included in Executive Order 122, such as promoting frequent hand washing, encouraging sick workers to stay home, encouraging good respiratory etiquette, such as covering coughs and sneezes, providing customers, workers, and the public with tissues and trash receptacles, discouraging workers from using other workers' phones, desks, offices, computers, work tools, or equipment whenever possible, routine cleaning and disinfecting of surfaces, equipment, and other elements of the work environment using cleaning chemicals designed specifically for COVID-19. You may be doing a lot of these things already, but the key in terms of what we're talking about today is to have everything you're doing put together in a written plan. That's what OSHA is recommending. The plan should also include policies and procedures for identifying sick employees. One of the things that some companies are doing, it's not required, is having daily temperature checks. In Pennsylvania, they're actually requiring this in certain circumstances. And again, while it's not required in New Jersey, some are choosing to do that as an extra measure of safety. Your policy should cover procedures requiring employees to report to management anytime they're sick or experiencing any symptoms of COVID-19, or anytime a member of their household has COVID-19, or anytime they've had close contact with someone that tested positive for COVID-19. Those things should be required by policy. Every business will have employees that are not able to come to work because they are sick with COVID-19, or were exposed to somebody who was sick with COVID-19. The company needs to decide to what extent these employees will be given paid leave as opposed to unpaid leave for the time that they miss work. So one of the things you have to be aware of is whether or not the paid leave under the Federal Emergency Paid Sick Leave Act or the Emergency Family and Medical Leave Enhancement Act is applicable to your business. These laws, new federal laws, provide guaranteed paid leave to employees that are eligible, but the laws are only applicable to employers that have less than 500 employees.
Doug, can I interrupt real quick?
Sure.
Sorry, normally we do questions at the end, but this person did bring up something that you did just address, and I think maybe you might want to expand on it a little bit. This one person just saying their HR company said that there was an issue with them checking temperatures. If you could just explain that a little bit more. Normally I would have waited till the end, but I think that was important enough to, if you could address that.
Well, I don't know what the issue is. There's a lot of issues with checking temperatures. Any employer that decides to do that, there's a lot of things that have to be thought through with it. So one of the biggest issues to be concerned with temperature checks is privacy issues. So, someone's temperature is their health information. And so when you take a temperature of an employee, that has to be kept totally confidential. So that's one of the biggest issues that companies are having. If you're trying to do this like as they come into work and you're taking someone's temperature as people are kind of lined up walking in, you can't make it noticeable that someone just failed and like in front of everybody else send them home, because that's a violation of their privacy rights, and it's a problem under the EEOC. So it has to be done in a way that protects that, and that's the biggest challenge that I think probably the HR company that they've spoken to was probably referring to.
This is Dina. Brigette's going to touch on that when we talk about updated EEOC guidance and workplace accommodations with respect to COVID-19. So Brigette will touch on that again, when we get to her portion of the presentation.
Yeah, but it is a really good point, and it's definitely something that before someone decides to go forward and do the temperature checks, you want to make sure you're doing it in a way that doesn't create more problems for you than what it accomplishes. So the next piece of the plan that we're talking about with OSHA is having a return to work policy that follows CDC guidelines. So for sick employees, those with COVID-19, the CDC provides a protocol that needs to be followed when you're deciding that an individual with COVID-19 can safely discontinue home isolation and return to work. There's two different tests that can be followed. They depend on whether or not the individual was tested for COVID-19. So if the individual does not get tested, there's three criteria. One, they must have gone 72 hours without a fever and without using fever-reducing medication. Two, they have to have improved respiratory symptoms. And three, 10 days must have passed since the symptoms first appeared. If those three things are there, the person can come back to work. The second test is if they do get tested for COVID-19. In that case, they can come back to work when they have no fever, they have improved respiratory symptoms, and they received a negative test for COVID-19 twice in a 24-hour period. So that's for sick employees. There's separate rules that apply for when someone can return to work when they're caring for family members that have COVID-19, or they had close contact for a prolonged period of time with an individual with COVID-19. I want to talk about those terms a little bit first to make sure that people understand them. The term close contact, the CDC defines that as within 6 feet. So close contact is you're within 6 feet of a person. And the term prolonged period of time is really undefined, but there's a few different places where the CDC references periods as at least 10 minutes. So what we've been advising clients is if there's a person that knows that they had contact with someone with COVID-19, meaning they were within 6 feet of that person for 10 minutes or more, that person then needs to be quarantined, okay? Now, the CDC generally recommends that the employee would need to stay home and quarantine until 14 days after their last exposure to the individual with COVID-19. So if this was a one-time contact with an individual, such as coming in contact with a coworker or a friend that was later diagnosed with COVID-19, it simply requires a quarantine of 14 days from the date that exposure occurred. However, if the person is caring for an individual, like a family member that lives in their household and has COVID-19, the employee would need to remain quarantined even after that sick individual has improved and is better. At that point, that the individual that was sick would have been able to discontinue home isolation. Then the employee still has to wait 14 days from that point until they could be permitted to leave the quarantine and return to work. So for someone that has someone in the household, it could be quite a period of time that they would have to be out. On April 8th, the CDC came out with revised guidance that applied to critical infrastructure workers who were asymptomatic but may have been exposed to someone with COVID-19. And employees in that situation, the CDC said, could return to work sooner than the 14 days if certain practices were followed. I'm not going to go into that because car dealerships are not considered critical infrastructure employees. And so this revised guidance that would allow a quicker return to work for these people would not apply. So for car dealerships, employees need to wait that full 14 days since their last exposure before they can be permitted to return to work in order to comply with the CDC guidelines. The next piece of the COVID-19 preparedness and response plan is that it should detail all the workplace controls that have been implemented by the company. So there are three different types of workplace controls to consider. The first are engineering controls. These are things like physical barriers, such as a shield guard between the customer and the cashier, marking the floor to demarcate 6 feet of spacing in checkout lines to demonstrate appropriate spacing for social distancing, increasing ventilation rates in the work environment, Those type of engineering controls should be spelled out in this plan. The second type are called administrative controls. And many of these are required by Executive Order 122. They include things like limiting the occupancy of the dealership to 50% of the stated maximum store capacity, providing employees with break time for repeated hand washing throughout the workday, replacing face-to-face meetings with virtual meetings, requiring social distancing, reducing contact among employees and between employees and the public, providing workers with training on use of personal protective equipment, how to put it on, how to wear it, how to use it, and other safe work practices, such as providing employees with resources that promote personal hygiene, such as no-touch trash cans, tissues, hand soap, hand sanitizer and disinfectants, and requiring hand washing regularly by employees. Those are the administrative controls. The third type of workplace controls that need to be included in the COVID plan is something detailing the personal protective equipment that will be utilized by employees in the workplace. So the employer needs to demonstrate in the plan what PPE is needed and to ensure that a proper supply of it is on hand. PPE are things like face masks, rubber gloves, goggles, face shields. There was a shift early on. Originally, the CDC was not recommending that individuals need to wear face masks. And then in April, CDC changed the guidance, and they now recommend, as I'm sure you know, that employees wear a face cloth covering when their job is in a public setting where other social distancing measures are difficult to maintain. This is consistent with the New Jersey requirement for car dealerships in Executive Order 122, which requires employees to wear cloth face coverings unless it would inhibit the individual's health. Okay, so that's it. That covers the disease preparedness and response plan. Even with a great response plan in place, employers are likely to encounter other safety-related challenges as a result of COVID-19. We are actually hearing more and more cases where employees are telling their employers they don't feel safe coming to work. And we should anticipate more of that as more and more employees come back to work and businesses that have been shut down begin to reopen. Depending on the circumstances, enforcement of an employer's attendance policy or disciplining an employee for their refusal to work, it could constitute unlawful retaliation under OSHA's anti-retaliation provisions. So you're going to want to really be cautious about this and seek legal advice if that situation arises. In general, OSHA does not permit employees to simply decide for themselves to not come to work because they don't feel safe. It does protect employees under very limited circumstances. So the basic case law that's arisen on this under OSHA is that there's 4 things that would have to be in place for an employee to legitimately refuse to come to work based on their feeling unsafe. I'm going to go through those. The first is, prior to their refusal to work, the employee must have brought the allegedly dangerous situation to the employer's attention, and the employer must have failed to correct it. Second, the employee's refusal to work must have been based on a good faith belief that the situation was dangerous. Third, it must be reasonable under the circumstances to conclude that if the employee were to come to work, there's danger of death or serious illness. And last, there must be insufficient time due to the urgency of the situation to eliminate the danger through regular enforcement channels. When all of these criteria are met, an employer's enforcement of an attendance policy or disciplining an employee for refusal to come to work might constitute unlawful retaliation under OSHA. OSHA has yet to provide guidance exactly on how these criteria would be interpreted under the COVID-19 pandemic, but it does seem to me that if an employer has taken steps to do the best they can to make the workplace safe, such as implementing a comprehensive response plan like we talked about. An employee's generalized fear that they will get COVID-19 if they come to work alone would not protect an employee from discipline if that employee refuses to work. Of course, these situations have to be looked at case by case, but in most cases, I would think an employer could enforce its attendance policy and could discipline employees under these circumstances. Speaking of retaliation, given the amount of fear that employees have pertaining to COVID-19, we are seeing a major uptick in the number of employee complaints about the safety in the workplace. Employees are complaining to management on a variety of safety issues, from fears that coworkers are being permitted to work despite symptoms of COVID-19, to concerns about the employer's cleaning and disinfecting practices. Employers must beware of OSHA retaliation claims for any adverse action taken against an employee after they've brought these type of complaints about unsafe conditions. OSHA can impose significant fines for these violations, often in the six figures. So after you get a complaint like that from an employee, even when it's totally unrelated and you're looking to take some sort of adverse action, you have to think about whether you're protected from an OSHA retaliation complaint. Another common question that we're getting is, must an employer include an employee's COVID-19 as a reportable workplace illness on the OSHA 300 and 301 logs? The employee's COVID-19 must be work-related to be reportable on the OSHA 300 log. If it's more likely than not that exposure in the workplace caused the employee to contract COVID-19, then the illness must be recorded. In its revised guidance on this subject on May 19th, 2020, OSHA recognized that in most cases, it will be difficult for an employer to determine whether a COVID-19 illness is work-related, especially when the employee experienced potential exposure both in and out of the workplace. In these situations, the illness is not recordable. OSHA's guidance document indicates that it will assess an employer's efforts in making work-related determinations. So they really don't want employers to just automatically say something's not work-related. They want employers to go through a little bit of analysis. And they said they're going to look into how you made the determination. They also said it would be sufficient. They would consider it to be sufficient effort if the employer, one, asks the employee how he believes he contracted COVID-19. Two, while respecting the employee's privacy, discuss with the employee his work and out-of-work activities that may have led to the COVID-19 illness. And three, review the employee's work environment for potential COVID-19 exposure. Ultimately, unless several cases of COVID-19 develop amongst employees that work closely together without an alternative explanation, or where the employee becomes ill shortly after a lengthy close exposure to a coworker or customer that was a confirmed case of COVID-19 without any alternate explanation, the illness is likely not going to be recordable on the OSHA 300 log. Now I will turn things over to my partner, John Vreeland, who's going to speak about protected concerted activity during the pandemic. John?
Okay, I'm going to just give you a little introduction on John. And I also, this is Judy, Vann. Anybody of you know, during the workshops, I like to be cognizant of time. So if you've allotted till 11, we probably will go beyond that because you've got 4 great topics here for 4 great people, and I don't want to cut any of them short. So John Vreeland is also a partner in the wage and hour compliance, and we'll go over the wage and hour issues in the new normal. So John, thank you so much.
Okay, I'm sorry, Judy, real quick before John starts. If anybody does have to leave at 11 o'clock, we are recording this webinar. We will be posting it to the website this afternoon along with the slides. So if you miss anything, you will be able to come back and check it out afterwards. Just wanted to throw that out there for everybody.
John?
Okay, thanks, Judy. So I'm going to move through these next few slides pretty quickly and get into the wage and hour issues, but we still have to be cognizant of protected concerted activities. So the National Labor Relations Act gives employees the right to organize and to discuss for the benefit of the group their terms and conditions of employment. And if you do anything that infringes on these rights, they can go to the National Labor Relations Board and file an unfair labor practice charge and allege that you're either discriminating against them or interfering with their protected rights. And we always caution our clients about being very conservative when doing anything that can any way interfere with protected activity under the National Labor Relations Act, because it's very easy for employees to file an unfair labor practice charge, or you've probably heard it referred to as a ULP. Basically, they just go down to their regional office, which for us is probably going to be in Newark, for parts of central and southern Jersey to be in Philadelphia, and they fill out a one-page form. It doesn't cost anything. It takes a few minutes, and then you have a federal complaint filed against you that's going to be result in an investigation by a federal enforcement agency. And then you'll spend the next couple of months under investigation, and if there's a complaint found that you violated the National Labor Relations Act, you'll end up before an administrative hearing. Judy, am I controlling the slides?
No, just say next slide, John.
Okay. Yep, next slide. So when we counsel our clients on remaining union-free, we give them what we call union-free training over the years. It's funny. What we always say is it's not the things that you would think, like pay and better benefits, that usually lead to employees inviting the union to the workplace. It's often other things, the fuzzier things like respect, and in this case, health and safety concerns. And that's something that union organizers are capitalizing on. They're playing up that the unrepresented employees are not being treated fairly because their employer hasn't implemented enough safeguards, hasn't provided enough PPE, and if a union was there, they would never let that happen. They'd file grievances, take the employer to court, and so the COVID-19 driven safety concerns is provide an area for union organizers to capitalize on. Next slide. Unemployment benefits, we talked about this last time. So most of our clients are wrestling with the employees who are doing as well or maybe even better on the enhanced unemployment benefits that are being offered by New Jersey and especially the federal government. And so as you're calling them back to work, you may find employees who just say, I don't want to come back to work. And what we've been telling our clients is that employees who don't come back to work, they're basically abandoning their job. And while they may prefer to stay on unemployment benefits, you need them to come back to work for various reasons. And one of the ways you can usually get them back to work is just telling them, okay, that's your decision to stay out of work, but there's work here for you. There's a job for you to be doing. And we have an obligation, just like you do, to notify the unemployment office that there's work for you, and it's probably going to disqualify you from receiving future unemployment benefits. And to the extent you do, you'll probably have to pay it back at some point. And that usually gets them to return to work. The next slide. Okay, so now I'm going to talk to you about a few wage and hour issues that have been coming up as our clients have been transitioning their employees back into the workplace and allowing others to work from home. So the first couple are compensability issues raised by COVID-19 policies. Most of you probably have implemented a policy that requires employees not just to wear face coverings and practice social distancing in the workplace, but also requires them to do things before they come to work, like submit to temperature checks and screenings, either as they arrive at work or before they even leave home and arrive to work. And I have one client that requires its employees every day, every morning, to respond to a series of questions through email before they report to work. And so whenever we're requiring employees to do something in connection with beginning their workday, we have to consider whether or not this time is compensable time, whether or not they have to be paid for it. And arguably, waiting in line to have your temperature taken or answering a few questions before you clock in is not compensable time. And that's because under the Fair Labor Standard Act's Portal to Portal Act, generally employers are not required to pay the time employees spend on activities occurring before or after they perform what are called their principal activities. However, if the thing that you're requiring them to do before or after their shift is deemed to be integral and indispensable to their principal activities, then the time does become compensable work time. And as you can imagine, what is integral and indispensable is not always clear. For example, washing up before or after work generally is not compensable time, but depending on the job, it could be. So if your employees are in a job where they're using particularly toxic materials, and then washing up may be considered integral and indispensable because it involves worker safety and it could become compensable. So given that these are often gray legal areas, my recommendation has been, and especially right now, is to be conservative and treat required activities under your COVID-19 policy as compensable time. We're obviously in new territory right now. My guess is the New Jersey Department of Labor will continue to be aggressive in protecting the state's employees, which means they're most likely going to err on the side of finding time to be compensable. In addition, even though these activities take just a minute or two, they add up and they can become the basis for very costly wage and hour litigation. We see a lot of this in payroll rounding cases where an employer has a policy that rounds payroll up either to the nearest quarter hour, nearest 7 minutes, or nearest 5 minutes. And then they're somewhat inconsistent with the federal and state regulations. Now, usually, even though the policy is unlawful, the individual effect of these policy causes just a slight deviation of maybe a few minutes per pay period per employee. But these minutes add up, and they often result in class action lawsuits. And even though each employee in the end may be entitled to just a few hours of pay, the legal fees end up driving the lawsuit and usually are significantly greater than the unpaid wages. And that's because not only are you paying your lawyers to defend you, but if your policy is struck down, you're then paying the plaintiff's fees and costs. So even though these temperature checks and these screenings may just be taking a few minutes, the safer approach is, or the safer practice is to conduct them after the employees have punched in to work. Otherwise, again, even though it's just a few minutes here and there, you make yourself a target for a plaintiff's lawyer, and we fully expect that plaintiff's lawyers are going to be looking for COVID-19 driven wage and hour issues because they're so lucrative, because if they win, they're entitled to their attorney's fees. Another issue that comes up with your COVID-19 policies is when you send employees home because he or she has been exposed to COVID or he or she is symptomatic. Now, for your hourly non-exempt employees, there's no issue. These employees are entitled to be paid for actual hours worked only. So once they're out of PTO under your policy, under federal and state law, generally you can put them in unpaid status until they're cleared to return to work. But this is not the case, or at least not always the case, for your exempt employees. And that's because in order to treat an employee as overtime exempt, you have to pay them on what's called a salary basis, which means each work week they get a fixed salary, and that salary doesn't deviate because of the quality or the quantity of their work. Or stated another way, there's no docking, and they're entitled to their full weekly salary in any work week in which they perform any work at all. Meaning if they work an hour on Monday, that triggers an entitlement to their full weekly salary. Now, there are exceptions to this, such as if the employee can't come to work because of illness, disability, personal reasons, they have a closing, their car broke down, things like that. In these cases, you can make deductions from their salary for full day absences in which they perform no work. However, when you send an employee home because the employee was exposed to COVID-19, or at least you think they were, or they're symptomatic, that employee is not out due to illness. That employee is out because management doesn't want the employee at work, and understandably. But assuming that employee is ready and willing to come to work, the employee has to be paid his or her full salary, even though there may have been a day or days during the work week where they provided absolutely no work, because they're The salary basis requirement has been triggered because they provided some work. Now, obviously, the exception to that would be if they were out for an entire work week, then they wouldn't be entitled to their salary. So anytime you're sending your exempt employees home, your overtime exempt employees home, because of COVID-19 concerns, you have to think about the salary basis requirement, and you have to be very careful about deductions from salary, and violating the salary basis requirement can be very significant because it can result in not just losing the exemption for that particular employee, but for every employee in the same classification. So you want to be really careful when you're deducting anything from an exempt employee's pay. Okay, let's talk about a few telecommuting issues we've been seeing. And the first is off-the-clock work. Hourly employees, non-exempt employees, are entitled to be paid for all hours of work. It doesn't matter if it occurs outside the regular hours. It doesn't matter whether or not it was authorized, and it doesn't matter if it's just a few minutes here and there. You have to make sure that all time is tracked and that the employees are paid for all of this time. So how do you do that when your employees are working remotely? And it's not easy. The first thing you want to do is you want to make sure that your employees and their supervisors understand the importance of accurately tracking their time. Second, if you have a telecommuting policy, make sure it's been distributed recently and your employees understand it. If you don't have a policy, adopt one. If you've got people working from home, you want a telecommuting policy in place. And a good policy is going to cover things like the expected work hours, how rest and lunch breaks are handled, how employees request authorization to work outside the regular hours, and how they report inaccuracies in their pay. And then the final thing you want to do to protect yourself with your remote workforce is it's a good practice to have them certify each work week that their hours are accurate. And that can be a simple email to these employees, listing out what their daily hours were during the work week and asking them to reply to the email and confirm whether or not the hours are accurate. Another question that we've been seeing a lot is as employees move towards longer term or even permanent telecommuting is whether they are entitled to reimbursement for expenses they incur as they work from home. Things like office supplies, computer equipment and printers, to a portion of their costs for their cell phone and internet plan. These are all expenses that the employees are now incurring because they're working from home and they may not have been incurring those at least to the same extent before. More and more states in the country are adopting laws that makes it unlawful to require your employees to absorb costs and expenses that benefit the employer's business. New Jersey, thankfully, isn't there yet. And when an employee works remotely, the employee can be required to be set up from home at the employee's expense, even if it's the employer requiring the telecommuting arrangement. Now, the one caveat I would add is that employees cannot be required to absorb expenses if doing so would bring their pay below the federal minimum wage. So that means making sure each work week in which there are expenses that the employee can prove that he or she has absorbed, that the employee's pay minus those expenses yields an hourly rate that is at or above the minimum wage. And note that this is an FLSA issue. It's a federal issue, not a New Jersey wage and hour law issue. And because New Jersey's minimum wage is considerably higher than the federal minimum wage, $11 versus $7.25, this typically isn't a problem for New Jersey employers because the expenses probably are not going to eat up that extra almost $4 an hour above the federal minimum wage. But in theory, if you required an employee to go out and buy a computer to work from home and this zeroed out the employee's pay for the week, you would have a minimum wage issue for that work week. So just keep that in mind as you're requiring your employees to set up from home. And then one final issue I want to remind you about is the amendment to the New Jersey WARN law. And I covered this in both our March and our May webinars, so I won't spend a lot of time on it here, but our state WARN law, which is the law that governs employer obligations and mass layoffs and facility closures, was amended earlier this year, and it makes New Jersey by far the most aggressive state in the country when it comes to those obligations. And there are a lot of changes, but the most significant one from a cost perspective is that if a layoff or a closure is covered by the New Jersey WARN law, the employer now is going to have to pay each laid off employee 1 week severance for every year of service. The amendment was supposed to go into effect next month. Thankfully, the Murphy administration pushed another amendment through in April, part of which put these changes on hold, but it's coming. At some point, we're going to have to deal with this. And the amendment right now is scheduled to go into effect 90 days after the termination of the governor's stay-at-home order, which right now is scheduled for July 7th. However, the governor's been extending the stay-at-home order 30 days at a time, and expectation is that it's going to be extended again at least until early August. But at some point, the stay-at-home order is going to terminate, and as employers plan for potential layoffs in the fall, they're going to need to factor in the added severance costs, which can be significant, depending not just on the number of employees that are being affected, but also their experience with the company. The more years of service, obviously the more weeks of severance you owe them. So that's everything on my list, Judy. Thank you, everyone, for listening.
Oh, thank you so much, John. This is a great information. Doug's presentation and your presentation is giving them great stuff. So let's move on. We're going to now go with Dina Mastellone as a partner at the firm's Newark firm, and she's chair of the Human Resources Counseling and Compliance Practice, joined also by Brigette Eagan, who's counsel in the firm's New Jersey office. She's a member of the Employment Law and Litigation and Human Resources Counseling and Compliance groups. So they're going to go over the Americans with Disabilities Act and the updated EEOC guidance. So I'll turn it over to you guys.
Thank you, Judy.
Go ahead, Brigette.
So we are going to go a little off script today to make up some time, but you're going to get the key essentials of it all. Judy, next slide, please. First, a couple of dates just to keep handy. Our daycares have opened already June 15th. Summer camp will be opening shortly, July 7th. So hopefully your employees will be able to have their children enrolled in programs to allow them to come back to work. If those programs are canceled only due to COVID, they can still use their emergency family leave. And if school does not reopen in September, if they have any of those 12 weeks left, they'll be eligible to use them. Next slide. Doug talked a lot about screening, but there is brand new EEOC guidance, which is updated 2 times in 30 days already. You can ask your employees if they have COVID-related symptoms before they come into your workplace. Next slide. When you get that information, as well as temperature information, it does not go in their personnel file. It has to go into a separate medical file, and all of this is coming from that brand new EEOC guidance, but it reiterates a lot of the rules that we already played by. Next slide. Temperatures Doug went into, and we talked a little bit, one of you had an issue with temperature taking. Just a couple of things about temperature taking. That record goes into the separate file, and if an employee objects to the temperature taking because of a medical condition or because of a religious reason, the EEOC has told us, talk to the employee. We have a duty to interact with them to see if we can accommodate their concern. Next slide. Doug already covered this. We'll move on to the next slide. You can also, the EEOC has told us, have your employees submit to COVID testing, but employers have the obligation to find a company that is reliable, that does it the right way, and whose results and the false positives are not out of range. Next slide. Can you send an employee home who is sick? Yes, if the symptoms are related to the COVID-19 symptoms that Doug talked about. Next slide. And when that employee wants to come back, you can require a doctor's note. The EEOC tells us that the doctors are still a little bit overwhelmed, so the notes may be more informal. They could be emails. You should accept those and work with the employee. Next slide. Your employee has a pre-existing condition that puts them at higher risk to complications of COVID-19, and they come and they tell you that. The EEOC wants us to work with those employees and interact with them through our ADA process. And the EEOC offers some solutions to these types of problems. Scheduling employees where it is less busy and these employees will come into contact with less people. Reconfiguring the workplace, putting up plexi barriers, temporary job restructuring of non-essential duties, temporary transfers, and of course, all of the physical changes that are required, like the floor markings, the social distancing. Next slide. An employee tells you that they had a mental health condition prior, and COVID has really made it worse. The EEOC has made it very clear to employers, yes, take those employees into your ADA accommodation process, work with them, and interact with them to see if you are required to give them a workplace accommodation, which is probably leave if it's not an undue hardship. And all of that is what we were already doing. Next slide. Same process that we already had, talk to the employee. If the condition is not obvious, we can ask for medical documentation. Next slide. And again, you know, we have the right to ask the employee how this accommodation that they seek will fix the problem, and we can revisit the accommodation as well. In a couple of slides, you'll see, and we'll talk about it here to save a little bit of time. Because of COVID and because everything is changing so rapidly, the EEOC suggests that if your employee needs an accommodation, that accommodation could change in 30 days when restrictions change. For that reason, employers are permitted to tell employees, yes, I'm going to accommodate you, and this is what we're going to do, but we're going to try it out for 30 days. We're going to see how it goes, and we're going to see if anything needs to be changed. So you can put limitations, time restrictions on the accommodations. However, when that time runs out, if the employee still needs that accommodation or a different one, our duty to interact is re-triggered. Next slide. We talked about the end dates of accommodations, and as far as how things shift and change, if we have limitations of half capacity now and our employee doesn't have any type of complications and can do that, when capacity goes up to 100%, our high-risk employee with underlying health conditions might need an accommodation at that point. So the EEOC reminds us that this is an ever-changing situation, and employers, keep your guard up because you will be held accountable if your employee subsequently asks for help. Next slide. If our employees have a pre-existing condition and have an accommodation, and we anticipate that they will need something else as they are brought in, the EEOC says that employers, you can start the process earlier, jumpstart things by asking the employee if they will need anything when they return to the brick and mortar site. Next slide. As far as the accommodation process, employers don't have to accommodate if that request creates an undue burden. And that has been historically a very, very high burden. The EEOC, the courts didn't really care about employer expense. Next slide. Because of the pandemic and because of the loss of business and how sales have really crippled a lot of employers, the EEOC says that now employers, you can consider your available funds when making accommodation decisions that are based upon monetary concerns. Again, tread very carefully here. Next slide. PPE. People might need accommodations with the PPE that you give them. Latex gloves, somebody might have an allergy. Because of religious reasons, beards, somebody might need a different type of mask. An asthmatic might need a face shield instead of a mask. Next slide. High-risk employees that do not request an accommodation. The long and the short of this is it deals mostly with pregnant employees and employees 65 and older. The EEOC has said, employers, if you are benevolent and you are trying to protect these employees and keep them out longer, that is unlawful. Unless they ask for an accommodation, like everyone else. Next slide. The exception is, we could even advance one more. The exception is that if an employee, a pregnant employee has a medical condition or complication related to the pregnancy, we can always accommodate that. And we know that pregnant employees, that condition alone entitles the employee to accommodations, such as more frequent bathroom breaks, not standing all day. So the message with pregnant employees is if they ask for help, we want to be really careful because it's still unclear how much help we give. But that's the one where you consult with counsel and we sort that out. Next slide. Next slide. Okay. Age 65 and older, the EEOC has come out and said that just because someone is in that age protected group and just because the CDC tells us that that protected group is more vulnerable to COVID, we cannot exclude them from the workplace. However, they kind of contradict themselves in this brand new guidance that came out June 11th, and the EEOC said, you'll see in the third bullet, we can afford that group flexibility. So again, we don't want to affirmatively say to this group or the pregnant employees, stay home. Let's wait until they come to us. And again, we want to be very, very careful and tread lightly here. Next slide. With age especially, the EEOC tells us we want to be really careful that we treat everyone the same because we want to protect ourselves from claims that we're treating one class of employees differently than the other. So again, we just have to be careful when we deal with these areas. You know, the EEOC gives us guidance, but they leave it so vague that it is still, we have to figure it out as we go. Next slide. Again, being proactive, as you recall more employees to work, the EEOC tells us that we can, if we want to, put a little note in our recall notice, letting employees know that if they need an accommodation to reach out. Next slide. And again, we touched upon this. If an employee objects to the screening process, we should find out why. And if it is because of religion or medical reasons, we should talk to them and try to figure out what the issue is and see if we can work through it together. Next slide. Okay, I think Dina, we're on to you.
Hi everyone, good morning. I'll run through my slides and again, like all, so we can get to the PPP update by my colleagues Keith and Young G. But just kind of wrapping up everything that Doug and John and Brigette have spoken about, it's now more important than ever that we're updating our policies and our handbooks, or we're issuing new policies to our employees that include a coronavirus leave policy, a teleworking policy, a return to work policy, screening and accommodation policy. You know, those of you who have updated your handbooks in January, certain policies also need to get updated in light of the changes to New Jersey Family Leave Act, FFCRA leave. Next slide, Judy. I just wanted to briefly talk about some anticipated litigation trends that we've been seeing over the course of the past 3 months. As everyone knows, New Jersey and the federal government passed laws allocating increased protection to all New Jersey employees. We obviously have the federal law, the FFCRA, as well as amendments to the New Jersey Earned Sick Leave Act and the New Jersey Family Leave Act. And not surprisingly, the plaintiffs' bar have begun filing pandemic-related complaints against New Jersey employers in both federal and state courts. Almost all of these lawsuits are brought under the New Jersey law against discrimination, which employees have 2 years to file, and the Conscientious Employee Protection Act, what we call SEPA, which is our New Jersey Whistleblowing Act. And they have been filing these fast and furious starting in April. The reason, of course, is because both statutes provide very generous damages in terms of potential for uncapped compensatory damage awards, back pay, front pay, as well as punitive damages. And of course, the driver of all these lawsuits, attorney's fees. So there have been already, as I said, many litigation cases already filed in federal court over leave requests for the employer not properly designating leave of absences either under the FMLA, the ADA, which Brigette spoke about at length, and as well as the FFCRA for school closure leave, care of a family member, etc. Some examples of these New Jersey lawsuits include ones filed for interference, the failure of the employer to notify employees of their rights under these statutes, denying leave requests in spite of the employee's physicians requiring them to self-quarantine and actually show up for work. Another category of other claims that have been filed are for high-risk employees, those employees that are seeking protection based on pre-existing conditions or illnesses, making them particularly vulnerable to COVID-19. And that's kind of what Brigette was talking about also in age categories, especially those for employees 65 years of age or older. So we have to be on the lookout of the high-risk employees and, of course, health and safety complaints, as Doug mentioned, under OSHA and the CDC guidelines. These trends are a good indicator of what's to come for employers preparing for reopening, right? Many employers fear that the reopening will create even more exposure, so we have to be on the lookout. And in the words, the sage advice of one of my colleagues a few months ago, we need to remember that COVID will eventually subside, but the anti-discrimination laws here in New Jersey especially are here to stay. And we, get litigation reports every day from every county in the state of New Jersey, and the top 3 cases, the top 4 cases in every single county on a daily basis are now all related to violations of New Jersey Leave Act laws, as well as whistleblowing cases. And on the slides that we have here, unsafe working conditions, discrimination claims, right? WARN Act claims, which is what John had referenced earlier, especially as the amendments to the New Jersey WARN Act come into effect, and the employers, listen, there may be a second round of COVID. That is what the CDC is indicating. And to the extent that there may be a second round of layoffs, a second round of furloughs, that is something absolutely that we all have to keep in mind, because the penalty provisions under the amendment to the New Jersey WARN Act are very severe. Next slide. We already talked about the disability discrimination claims, employee medical privacy complaints, ERISA complaints, right, which employees may seek recovery of losses, wage and hour issues, and the explosion of the class action cases. And I'll turn it over now to Young G and Keith so they can get to their PPP update.
Morning, everybody. Sorry.
Go ahead, Keith.
Sorry. Go ahead, Young G Park is the associate in the firm's counsel, and we're going to go on to Keith Krauss. Please hang in there with us, guys. We've probably put another 20 minutes, but they have very important information for you.
Morning, everybody. This is Keith Krauss. How you doing? We'll move quickly. We have done a couple presentations on this, so we're going to focus on the updates. As we've mentioned previously, we've been trying to hit a move.
Keith, we can't hear you, Keith.
Okay. Am I on mute?
Young G, you might take the lead until we can get Keith's audio back.
Sure. So as many of you probably know, Congress approved and President Trump signed the Paycheck Protection Program Flexibility Act of 2020. It purports to make a few changes to the program design. Could you go to the next slide, please? The bulk of the changes are outlined in this slide. It affects maturity for loans made after June 5th, 2020. The minimum loan term, or the SBA indicated in subsequent interim rules that the loan term will be 5 years from the date of disbursement. For those of you who are actively using your loan funds, you received the funds prior to June 5th. you may make modifications to extend the maturity date to the extent that, you know, a portion of to the extent that a portion of your loan proceeds may not be subject to forgiveness and you may have to repay. The loan forgiveness period has been extended to 24 weeks, not to go past December 31st, 2020. For borrowers who received funds prior to June 5th, 2020, you may elect to keep the 8-week covered period as your covered period for purposes of, you know, determining when costs should be incurred and paid, and also for purposes of determining the implications for workforce reductions and the like, all of the rules that were previously applicable. The payroll cost requirement, as many of you probably also know, that's been reduced from 75% of the PPP loans to 60%. In a recent interim rule, the SBA clarified that this is not a threshold requirement, that if for some reason you don't meet the 60% requirement, your loan forgiveness amount will just be reduced proportionately. But you do want to keep that in mind. And with respect to the forgiveness amount adjustments, there were a couple of clarifications with respect to exemptions, adding a few additional exemptions, such as if you're unable to rehire employees who were employed on February 15, 2020, and also unable to hire similarly qualified employees for unfilled positions on or before December 31st, 2020, you won't be penalized. In addition, if you're unable to return to the same level of business activity as you had prior to February 15, 2020, due to compliance with sanitation, social distancing, or other worker customer safety requirements of set forth by the Secretary of the Health and Human Services Department, the Centers for Disease Control and Prevention, or the Occupational Safety Hazards Administration from March 1st through December 31st, that will also excuse you or protect you from penalty or reduction in the loan forgiveness amount. You do have to make sure that you document any of these circumstances in the event of an audit or, you know, for review by your lender at that time. To the extent that you may be subject to a repayment of the PPP loan proceeds, for instance, if not all of your loan proceeds are subject to forgiveness, there is an extension of the deferral period, which is previously 6 months. It's now 10 months. The rule says that if you have not submitted your forgiveness application within 10 months, you're subject to repayment after 10 months from the date that you received the loan proceeds, in which to recommence your or to commence your payment of principal and interest on the PPP loan. If you submit your loan forgiveness application within the 10-month period and you're waiting for a determination, there's a bit of a grace period for you there as well. Next slide.
Can you hear me now?
Yes.
No? Yes?
Yes. Yes,
Oh,
Keith,
good.
do you want to jump?
Yep, Keith, you're good to go.
Yeah, sure. Okay, sorry about that. What we're talking about here, right, Youngji was just describing, the Congress did make some changes to the entire program a couple of weeks ago to really, I think, fix some limitations that the SBA had put on. So all the things that we're now describing are benefits to you guys in terms of your loan forgiveness as well as repayment if that happens. We now have an application for forgiveness, which is very helpful in terms of you filling it out. We've had a lot of questions over the last couple of months on various aspects of the forgiveness, and the application is very useful. As Youngji mentioned, the covered period has now been potentially extended. So in terms of forgiveness, generally speaking, you want your employees to make sure you don't get a full-time employee reduction or a salary reduction. We are also recommending to all clients that, as we did with respect to substantiating your certification of need, that you also document the daylights out of the support for your forgiveness application and the absence of any reason to reduce that. Support it with all your documentation with respect to full-time employees, salaries, et cetera, et cetera. Next slide, please. Again, what you're going to be eligible for in terms of forgiveness are payroll costs. The new legislation has given us a little bit of flexibility in terms of when we start computing the payroll costs. The covered period, again, which has now been extended from 8 weeks to 24 weeks, starts from the date of disbursement of your funds or from the date of your first pay period. That's probably not too much different, but might get you a couple weeks. In addition, there's a difference between payroll costs incurred and paid. Obviously, the payroll costs are incurred when the employee's pay is earned and paid when checks are distributed. The amount that you have to allocate towards payroll costs has been reduced by Congress from 75% to 60%. That gives you more flexibility. In terms of paying non-payroll costs, especially if you happen to be in a situation where you have high rent, you can now allocate more of your PPP loan proceeds towards rent, as well as interest on covered mortgages, utility payments, etc. So now you have more flexibility. Next slide, Pete, please. As we've mentioned in previous presentations here, you have to be careful about reductions to loan forgiveness in completing the loan forgiveness application. Youngji, you want to drill into the details for us?
Sure. So as you all are probably aware by now, reductions in workforce numbers or salary wage reductions in excess of 25% as compared with respect to the latter against the full quarter immediately preceding your covered period in which the employee was employed can impact your loan forgiveness amount. And that is, if you furloughed or laid off your employees after January 1st, or you reduced the salary or wages of any employee, were not compensated more than an annualized $100,000 in any pay period by more than 25% of the base salary or wages paid during the first quarter of 2020, then you could be subject to a reduction of your loan forgiveness amount. The loan forgiveness application contains worksheets that are aimed at helping to determine whether a reduction should apply. For workforce reductions, you'll want to review whether you undertook reductions in workforce after January 1st, 2020, and whether your reduction during the covered period, whether you choose, for many of you who received funds prior to June 5th, 8 weeks or 24 weeks as contemplated by the Flexibility Act at your election, assuming which resulted in fewer average FTE during this period than that maintained during either February 15th, 2019 through June 30th, 2019, or January 1st, 2020, and February 29th, 2020. Again, that's also at your election. If the average FTE during the covered period is lower than your elected comparison period or your reference period of last year or the first 2 months of this year, then you should see if a safe harbor exemption applies. I have in 2 slides later identified the main ones that you'll probably be looking to. A similar analysis should also be conducted for reductions in base salary or wages. But note that with respect to the safe harbor, the Flexibility Act did not address the salary or wage reductions that occur after April 26, 2020, as being eligible for the safe harbor for restoration by December 31st, 2020. That means that under the CARES Act, it had stated that reductions that occurred between February 15, 2020 through April 26, 2020 which are restored by June 30th, 2020, which has now been extended to December 31st, 2020, would not result in a reduction in the forgiveness amount. That's important if you determine to reduce salary or wages for the now 24-week covered period, and that reduction is more than 25% of the base salary or wages paid to such employee during the most recent quarter in which the employee was employed prior to your covered period. Again, the loan application assumes that that would be the first quarter of this year. Next slide. A few quick notes on the determination of your workforce numbers or your full-time equivalent employees. As you are also now aware, the SBA has determined to use a 40-hour work week as the basis for determining FTE. You can use the actual percentage allocation based on a 40-hour work week, such that an employee, for instance, working 32 hours a week would be 0.8 FTE. Alternatively, the SBA permits that you may use a simplified method where you designate all employees during each pay period who work a 40-hour work week or more as one full-time equivalent employee, and employees working fewer hours as 0.5. You do have to make sure that you're using this approach consistently if you do elect to use the simplified method, including when you're computing your average FTE for your reference period, being either of February 15, 2019 through June 30th, 2019, or January 1st, 2020 through February 29, 2020. Note that there's a slight divergence in the PPP Schedule A worksheet in the application for the calculation of the average number of employees from the CARES Act. The CARES Act states that for purposes of computing whether there's been a reduction in the average FTE, you should be calculating the average number of FTE for each pay period falling within a month. The PPP Schedule A worksheet, which is on the slide on the right-hand side, shows that requires you to assign an FTE designation for each employee. So you can see you have to identify all of your employees and provide a designation of their average FTE along with their salary reduction to determine your FTE count. So slight divergence. I think you should be making sure that you're calculating the FTE during the covered period in accordance with the CARES Act provisions also, just to make sure that you're covering your bases and you understand the implications of any reduction based on that. For instance, if you had to let someone go during the covered period and that employee's termination isn't subject to a safe harbor exemption. Next slide. As I mentioned before, under the existing rules prior to the enactment of the Flexibility Act, there were some exemptions from the reduction in the loan forgiveness amount for loss of employees, mainly stemming from employees who refuse to return to work. You must make sure that you adhere to this 5-prong test, i.e. that you've provided them with good faith written offer to rehire or restore them. You offer them the same salary or wages and the same number of hours as earned prior to their separation. The offer was rejected, and you should be documenting the rejection, and that you've made sure to inform the applicable state unemployment insurance office of the employee's rejection within 30 days of such employee's rejection. I think New Jersey requires that you inform them in a much shorter time frame. So you just want to make sure that you're maintaining records in accordance with these requirements. In addition, the Flexibility Act also states that you will not be penalized if you're unable to hire employees that were employed by you as of February 15th, 2020, and you're unable to hire similarly qualified employees for unfilled positions by December 31st, 2020, again, that also has to be documented. In addition, if you are unable to return to the same level of business activity as you had prior to February 15th due to compliance with new standards for sanitation, social distancing, and safety, customer and workforce safety related to COVID-19 between March 1st, 2020 through December 31st, 2020, that will also protect you from a reduction in the loan forgiveness amount. Again, you have to be able to document that and provide that to your lender and or the SBA, subject to any subsequent audit. Just wanted to note for everyone that new rules continue to come out of the SBA and Treasury Department frequently, and it's expected that additional rules will continue to come out as they implement the new standards under the Flexibility Act. Yesterday, they just issued new loan forgiveness application forms. There are two now. One is an easy application form for sole proprietors, self-employed individuals, and employers who have not experienced reductions in their workforce or reduced salary or wages. It's a little more streamlined. There's also the more comprehensive application for those who are subject to or who may need to work through the reduction numbers to make sure that your applications withstand scrutiny with respect to any of those reductions. Next slide.
Yeah, we want to real quickly, and we know we're running very late, just highlight some other funding opportunities that you still have available to you. We don't have a slide here on this particular one because, believe it or not, until Monday it was not available because it was only available for agriculture, but the Emergency Economic Injury Disaster Loan Program through the SBA, or EIDL as we call it, is back in play as of Monday for businesses such as yours. Similar eligibility requirements to the PPP loans, except they're not forgivable. But if you do need other sources of funding, you can apply to the directly to the SBA for an EIDL loan. They are low interest, no guarantees or collateral, up to $200,000 borrowed. So they do have some advantages. If you need any more information, let us know. Next slide, please. There are a number of programs still available, COVID-19 specific, through the New Jersey Economic Development Authority. There is a grant program, not a lot of money, and limited to very small companies, 25 or fewer full-time employees. I don't know if any of you qualified, but that is there. And there are a number of loan programs, one of which we mentioned in our last webinar, which is the Small Business Assistance Guarantee Program, where the EDA will guarantee certain loans that you can get through specified lenders. They also now have a micro loan business program, loans up to $50,000 for New Jersey businesses with fewer than 10 employees. A small business fund, loans up to $500 for NJ businesses with up to $3 million in revenue. And regular old garden variety NJ EDA loans up to $750 for working capital, subject of course to their limitations. Young G, you want a quick Main Street lending program through the Treasury Department, and I guess that'll do it. Next slide.
Yes. So the Federal Reserve issued 3 term sheets for its Main Street lending program for the Main Street New Loan Facility, Expanded Loan Facility, and Priority Loan Facility. Essentially, they provide loan funds, minimum loan size to maximum loan size vary depending on the product that you're seeking. All of them come with a 5-year maturity and graduated repayment schedules, including a principal payment and interest payment deferments. These are at a cost to the borrowers, and they are subject to obviously interest. Currently based on the adjustable rate of LIBOR plus 300 basis points. They're a little more stringent. None of these loans are forgivable. And all of you who receive PPP loan funds are not disqualified and remain eligible to seek funding from lenders who are administering or participating in the Main Street Lending Program. You will be subject to general or ordinary underwriting, although lenders with the Federal Reserve's participation are somewhat more incentivized to provide this kind of financing. If you have any questions with respect to eligibility, again, the criteria is very similar to eligibility for PPP, except for that it's not limited to small businesses. You can see in the last bullet of each of these slides, the minimum employee requirement is 15,000. The minimum annual revenues based on 2019 figures is $5 billion or less. Again, it's financing that you would be applying for through lenders participating in the Main Street Lending Program. But if you have any questions with respect to eligibility or the specifics of financing, please feel free to reach out. I think that concludes
our presentation. Yeah.
Judy.
Okay, so myriad of information. Thank you, all of you, for hanging in there with us. I kind of figured we'd go to 11:30, but we do want to make time for some Q&A. So Brian, do we have any questions that came up during the presentation?
Yes, and obviously in the interest of time, and so we don't repeat too much or get too far off on a tangent, if a question was covered, I'll ask the presenters, whoever answers, you can refer people to review the slides or the recording of the webinar, both of which will be posted on the website later this afternoon. If a question is just too specific, ask them to contact you directly after the webinar, again, just to try to move things along. There are a couple questions here that we have that don't look too hard. If we can answer them quick, go for it. Is it okay for employees to return to work within CDC guidelines without a doctor's note?
I'll field that. It's Doug Solomon. So interestingly, when someone is sick and then they are looking to return to work, let's say they had COVID-19, they were positive for COVID-19, and now they say they're recovered. There's a real question about whether it's safe to just rely on their own representation. According to the CDC, and actually OSHA has had comments that are the same, what their current guidance says is that you should not require employees to submit a doctor's note. It concerns me a little bit because if an employer allows someone to return to work based on their own word, and the person is actually still contagious, and then other people wind up, getting the illness because you allowed them to work, there's potentially liability there. So I don't know if I would automatically listen to an employee's own word, but I just have to let you know that the guidance from CDC and OSHA is that you should not require a doctor's note.
Doug, actually, the next question actually kind of flips that on the other side. Can the employer request a copy of the COVID test results? To your point, to not accept their word for it, but have a copy of the results.
If it was me, my recommendation would be that you do that because it protects you. There's some, as I said, it's the same answer I just gave. There would be some argument that you should not be able to require that based on the CDC guidance and the OSHA guidance. So you have to make a decision whether you want to rely on that or not. I would ask for it and maybe give a little leeway, because the concept the CDC was worried about is that doctors are going to be very busy at this time, and it may take them some time to get that to you. So I'd be patient in terms of the timing, but I don't know if I would let someone return to work based on their own word without seeing the negative test.
So I've had that exact issue where we did not ask for the results, but the employee volunteered to do this, and they were fraudulent, which actually led to that employee's termination. I would much prefer a doctor's note clearing the employee to return to work, because, you know, the CDC and the ADA, the Americans with Disability Law, they're not working together, and they appear a little bit contradictory about what you can ask for and how far you can go. So the ADA does allow a doctor's note for a clearance, and unless the employee volunteers the information, I'll require the doctor's note.
This is Dina. I have to agree with Brigette, and you know, as Doug has already pointed out, the CDC guidance is just that. It's guidance, right? To me, as an employer, we need to be more worried about the EEOC and what the EEOC says that we can require, because that's where the lawsuits and the charges of discrimination are most likely going to come from. And Doug and I actually were just on a call last evening with a dealer client about their testing procedure, and a very important issue was raised. Make sure that the individual that is receiving these doctor's notes, that is receiving test results, etc., are not the employee's direct manager. That is very, very important, because as we've always said, in any interaction we have with employees with respect to medical issues, right, those documentation, that has to go to human resources, okay? That cannot go to the frontline manager. Why? Because you're going to have a retaliation claim, you're going to have a perceived disability claim, a failure to accommodate, right? So just like I had said, for putting the coronavirus aside, managers should never be receiving employees' medical information. So when you get those notes, when you get test results, if you do, make sure it's going to one central location, and as Brigette pointed out, not to the employee's personnel file, it goes to a separate file.
Okay. One more, this one also came in during Doug's presentation, so obviously anybody can answer it, but it may be aimed more towards Doug. Is OSHA, it's a clarification about OSHA. Is OSHA saying someone who is sick but never tested positive has to test negative twice before they can return to work?
No. No. That has to do with someone that was already tested positive and is out of work due to their positive test. So sorry if that was confusing. When I was talking about being tested, I was talking about on the back end. So this is someone who was tested, they tested positive, they're now out of work, they're home recovering. And the question is, when can they return to work? And if the test that I provided, that three-pronged test, has to do with when they're tested after later on to see that they have recovered, they have to have those two negative tests. So hopefully that clears the question up, but if anyone still is unclear, feel free to get in touch with me and I'll explain it further.
No problem. We just have about 4 or 5 questions here left. So let's through these and let everybody get back to their day. These had to do with, again, anybody can answer them, but these were part of John, in response to John's presentation. Employees are having a difficult time getting in touch with the Department of Labor. So if an employee refuses work, how does the employer quickly get in touch with the DOL to discuss the employee refusing to return?
I think the regulation says we have to notify the Department of Labor within either 48 or 72 hours. I don't know the mechanics of it. I've never been involved in the ground level when these issues come up. So I don't know how you reach out to them, but understandably, they're inundated, so it's probably not easy for employees or employers to get in touch with the Department of Labor.
Basically, just keep trying.
This is Dina. There's also a form to fill out that's on the Department of Labor's website, the refusal form and the notification form. And I believe there's either, and again, somebody can contact us and I can kind of direct you to that spot on the Department of Labor website. But there is a form released by the Department of Labor and instructions on how to file that form and get it to the Department of Labor.
Okay. Can we substitute time off with sick pay? Say an employee worked Monday and Tuesday, then on Wednesday morning we sent them home. Can we use sick time for Wednesday, Thursday, and Friday?
So I assume we're talking about exempt employees. And the answer is, as long as your policy contemplates it or allows it, then yes, you can. And one of the exceptions to the salary basis requirement that I talked about is if the PTO policy sets a certain number of PTO days for exempt employees, and then if there's language in there that says you can be sent home or required to stay home due to illness or disability under the PTO policy, then it would be fine. Probably policies weren't contemplating these types of situations, so the language might not be there. So it's unclear whether the Department of Labor would allow that to happen.
Okay. Just three more here. I think people have had enough legalese. No offense to anybody. If an employee is sent home because they have been exposed and they are expected to work from home, are they entitled to full pay if they are salaried?
So if we're talking, John again, if we're talking outside of their protected paid time off under state and federal law, so they've exhausted their leave and now they're working from home, they're not entitled to their full pay. And you can change an employee's pay prospectively at any point for both exempt and non-exempt, as long as they know before they start working under the new pay plan what that pay plan is. What you couldn't do is you couldn't take an overtime exempt employee, tell that person he or she has to work from home, and then convert that employee on a daily basis to hourly, unless you did it for the whole work week. Because again, a salary basis requirement is once the employee does any work at all during the work week, that triggers an entitlement to the full salary. So you can't reduce the salary. You could do it prospectively for full week increments, but even then, I've had cases where the Department of Labor doesn't like when employers convert our exempt employees to hourly and then back to exempt too frequently, because it can be manipulated to avoid overtime.
Okay. Last two questions. What can a dealer do if an employee does not want to return to work because they live with someone with an underlying health condition? I guess it's not themselves, but they live with someone with an underlying health condition.
So for that one, I was going quickly through my slides and I might have passed through that one. That EEOC guidance, that is the very most helpful part of the guidance. If your employee is not caring for that person and there's no immediate a need for FMLA, there is no protection in that scenario. If that person doesn't have COVID, or if that person that lives in the household, our employee doesn't qualify for FMLA to care for that person, we can require our employee to come back to work.
That actually kind of dovetails into the last question, so that was a good answer. In light of daycare centers and camps reopening, what proof can an employer ask for if an employee wants to stay out on FMLA?
So the employee, and Dina and I go back and forth on this, because the open issue is, if your camp is closed, do you have an obligation to find another one that's open? And the law so far doesn't go that far. It doesn't make that requirement. Dina, I think we both agree on that, right?
Yeah, absolutely. And another issue we have is that, can we say, just because daycare is opened on June 15th doesn't mean that an employee's individual daycare has opened. Many have, but so equal numbers have not. They've either delayed, they don't have enough staff to bring them back, right? They're still setting up PPE and barriers and everything else that they need to, because there are pretty stringent Department of Health regulations with respect to daycares, right? So even though daycares in general have opened and individual employees have not. So our recommendation, what Brigette and I say, is to get something from the employee to show that their specific daycare has not opened. But what do you do, right, when employees refuse to send their kid, right? It is their affirmative choice not to bring the kid to daycare, or their summer camp is open and the parent has voluntarily removed their kid from the camp. So it's very interesting, but I think an employer has a right to go back and ask for documentation, right, to show that the employer's camp is open, the daycare is open, is it not open? Because don't forget, under the FFCRA, where employees are getting school closure leave, as well as the New Jersey Family Leave Act, that is coming now with monetary benefits, right, Brigette? That's coming. You're getting money, you're getting tax incentives from the state, from the federal government. So I think, again, this isn't free. Somebody's paying for this. So you have a right to get the documentation, and I think employers have the right to do it and should do it.
Great. Well, that's it for our questions. I think, Anthony, did you have like a 60-second wrap up that you wanted to do?
Yeah, sure. I just wanted to, again, note, Doug said this earlier, but the by appointment only restrictions on showrooms were lifted on Monday as a result of extensive lobbying efforts by NJ Carr over the last few weeks. So to the extent that anyone's unaware of that fact, the by appointment only restrictions no longer apply. However, as Doug noted, all of the social distancing, PPP requirements and sanitization requirements of Executive Order 122 still apply, and also to the extent that those requirements mirror OSHA or CDC guidance, you still have to follow that guidance. So, business isn't necessarily back to normal, but the limitations on your ability to use your showrooms as far as appointments only have been lifted. So I just wanted to note that, and I wanted to thank all of our presenters, my former colleagues who I respect greatly, and I'm just happy to be able to continue to work with them in this context. And I think everyone did an excellent job at displaying and communicating the information that's kind of difficult and ever evolving, but in a manner that's easy to understand. So I wanted to thank you all for participating. Judy, do you have anything you'd like to say?
Nope, that's it. Thank you so much for everybody's time. I know we went over, but some great information here. So thank you so much, and go to the website and you'll have a great copy of this presentation.
That's great. Well, thank you to everybody. I'll just echo everybody else's comments. Thank you to everyone, all the presenters and the participants. That concludes today's webinar. Stay safe. Thank you.
Thanks, everyone.
Thank you.
Thanks,